Are you partly to blame for your slip and fall in California? If you have been injured in an accident and you think another person was partly to blame, you will need to understand how any compensation you receive could be affected. Let's imagine you were injured in a slip and fall on another person's property. You could decide to file a claim against the owner, but you will first need to understand that if you were partly at fault, the case may not be as easy to win as you think. The Statute of Limitations. The Statute of Limitations puts a deadline on the amount of time you have to file a claim. California's deadline for personal injury cases is 2 years when negligence or neglect is involved. If, however, your cell phone was damaged when you slipped and fell, you will be given a longer deadline. The deadline for personal property is 3 years, but you will have to file a separate claim. It would be wise for you to give yourself enough time to gather all your evidence and information together before the deadline runs out. 2 years for a slip and fall claim is not long at all, so you should ideally begin the process as soon as possible. If you miss the deadline that has been set by the Statute of Limitations, your case could be dismissed. Comparative negligence. You should be aware that the owner of the property in which you fell could make the argument that states you are partly responsible for your slip and fall. With the help of a lawyer, you should think about how you can counter the property owner's argument, as your award may be reduced if you are found partly at fault. Please read Defense Strategies to Use in a Personal Injury Case for more information. You will also need to show that you were supposed to be on the property and that you were where you were expected to be. You may not need to prove that you weren't paying attention to where you were walking unless the defendant argues that you were. You will need to prove that you were wearing the appropriate footwear, and you weren't taking a risk by being in an area that had been cordoned off for safety reasons. Irrespective of the argument that the owner of the property makes, if your case ends up in court, California's pure comparative negligence rule will make a difference to how much compensation you will receive. What the pure comparative negligence rule means. This rule means that any compensation you will receive is likely to be reduced according to how much you were at fault. Your measure of fault will be given in percentages, and if you were found to be 40% responsible for your slip and fall, you will probably receive 40% less compensation. This means that if your damages come to a total of $100,000, for example, you will only receive $60,000, 40% less than you would have if you were not 40% at fault. If your claim does not go to court. If your claim does not go to court, the comparative negligence rule will apply. The owner of the property and their insurance company are likely to be aware of the percentage of fault, or at least have some idea. The insurance company may, therefore, offer you a sum that reflects their level of responsibility, and yours. This is why it is so important for you to build a strong case, and do what you can to show that the other party is negligent.